Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Both partners are experienced trial attorneys who have been board certified in family law by the Texas Board of Legal Specialization.
Thanks for tuning into For Better or Worse, or Divorce podcast, where we provide you tips and insight of how to navigate divorce and child custody situations in the state of Texas. So I'm Jake Gilbreath, and today I'm joined by one of our associate attorneys in the Austin office, Stefani Preston-Kryder. She's going to join me as part of our series on Texas counties, where we discuss different counties and local rules throughout the state. And for this episode, we'll be talking about the Austin area and the surrounding counties. And so hopefully some of y'all find that helpful for anyone going through or knows somebody that's going through a family law matter in this part of the state. So thanks for joining, Stefani. And this is kind of out of your kind of usual day-to-day work with the firm. And so I appreciate you doing it. And why don't you start off by telling us a little bit about yourself, your background, kind of how long you've been with the firm, and anything you can tell us about yourself.
Sure. Happy to be here. I graduated from Baylor Law School in 2018. While I was there, I knew I wanted to work in family law, so I focused on family law, won the Family Law Advocacy Award there, joined Walters Gilbreath in May 2019, and I've been practicing exclusively family law since that time in Central Texas. So, since I joined the firm, I've written for and spoken at, some CLEs, including handling your first divorce, relating to inventories, creating property division spreadsheets, dealing with, unique property issues, prepping those for settlement and trial. I was just recently listed as a super lawyer rising star for the year 2023. So I'm happy and excited to talk about some unique issues to the Austin area because there's a lot of variety in how each of the counties operate. So it's an interesting, exciting topic for me.
Yeah, absolutely. And, Stephanie actually just joined me. I think it was last week. Yeah, last week we were speaking at the advanced family law class at Baylor Law and talked about child custody cases and jury trials, one of our favorite topics. And to brag on Stephanie too, I will say when we hired her, there's a hiring process in the law firm where we sit down and we interview people, and then after we interview them, we usually have them come back for a second round of interviews, and then kind of we think about it. We try to be very intentional about who we hire at the firm and associates. Stephanie came and met with us, and me and Sarah, the CEO, and we had the interview for the first time, and she left the office, and we made the decision to call her before she even got to her car and say, "Come work for us." Which was one of the smarter things that we've done at this law firm. So I'll brag on her a little bit.
My acceptance was one of the smarter things I've done in my career. So there you go.
Yeah, there you go. Oh, isn't this nice? So Austin, every single county is different, right? So let's sort of first say when we say Central Texas or Austin surrounding counties, let's kind of focus on Travis County, Williamson, Hayes, Bastrop County. I would probably define Central Texas a little bit broader than that, right? Going to Bell County, Burnett County, go down south to Caldwell County, Guadalupe County. Y'all know we have an office in San Antonio, so down Bexar County. But just for the purposes of today, let's kind of focus on those four counties because we spend a lot of time, frankly, based out of our Austin office in those counties. So, first thing to know when you're practicing in any court in the state of Texas, but particularly in these courts as well, is what the local rules are. So, Stephanie, first, can you talk to us about kind of when we say local rules and when we preach about local rules and we train our associates on that, or we talk to clients about it, or talk on the podcast, what do we mean? What is local rules for a court?
Sure. So I think people are obviously familiar with things like the Texas Family Code governs all of Texas family law, right? And we all look at that, regardless of what county you're in. Texas Rules of Civil Procedure and Evidence. Doesn't matter what county you're in. When you're in a specific county, each of those counties have the ability to regulate kind of the way that county runs, the way their docket runs, the way you need to be filing pleadings, what you need to be sending in. And they have the ability to control that to a large degree. And so it's really, really important, especially if you're practicing in a new county, to get on the, district clerk's website immediately and find what those local rules are. There are going to be local rules, and find out what they are, find out what the unique kind of little traps are. We'll talk about those in more detail as they relate to those counties that you spoke about, but they're kind of there's some of the pitfalls and gotchas that you can miss if you're not careful up front looking at what this county specifically expects from you in practicing in their county and bringing a case in their county.
Yeah. And the pitfalls, I mean, it really can be something as severe as, your trial may not go forward, right? If there's pre-trials that are required to be filed by a particular county under a particular deadline, and you don't file them, frankly, really bad things can happen in court. The least of which is, a judge can say, you haven't filed pre-trials, y'all get out of here, reset your case. That's actually probably one of the least bad things that can happen if you haven't filed pre-trials. A lot of the local rules, and we'll go in more detail in a second, but a lot of the local rules will say if you don't file your pre-trial documents per the local rules, per the deadlines, you don't get to present evidence, you don't get to ask for the relief if it's not contained in your pre-trials, right? So maybe you have a massive separate property claim, and you just didn't file your pre-trial on time asking for it. You could have a judge say you're not allowed to present that, even if you have everything else squared away. Stephanie and I have a case that went up on appeal where one of the many issues was that the appellee, the person who complained about the court's judgment that had filed the appeal after, the opposite side of the case that Stephanie and I had, one of the many issues was trying to kind of undo a mistake that they had done as far as confusing a reimbursement claim and a separate property claim. And the third court held them to their pre-trials on it, that they tried at trial to say, well, maybe it's a separate property claim because that was the actual correct way to present it. But their pre-trials had said, and their pleadings had said it's a reimbursement claim. And so the court denied the claim, and that got upheld. And one of the many reasons it got upheld was saying, pre-trials, look at your pre-trials, and you said reimbursement in your pre-trials was separate. So going back to that, why these rules can really have, and that was a, six-figure claim that, the local rules were discussed in the third court of appeals opinion. So I guess let's talk about pre-trials a little bit, Stephanie, because each county does have required pre-trials. So we don't have to go through in detail every single county and rattle off the rules, but just what in general are pre-trials that for a final trial that are typically required in this area of the state.
Sure. So pre-trials essentially are a way of you saying ahead of time, court and opposing counsel, here's notice of every claim I'm trying to bring and prove, right? And the evidence that I'm going to be, working with to prove those claims. Because in Texas, it's very important that we don't do this surprise gotcha trials, right? That's why a lot of the rules are in place, is so we don't go in and say, Judge, I didn't even know this request was at issue. So we list out, and we got to be really thorough and really careful, like Jake was saying with the mistake there with confusing a separate property claim versus a reimbursement. You have to be really careful with claiming exactly what you're asking for. Sometimes maybe even what we call pleading in the alternative, saying, okay, well, Judge, if you don't accept my request on this, then here's kind of my alternative request. Putting everybody on notice, putting the court on notice that we know what we're asking for, right? We're not coming in just kind of blind. And then, there are other pre-trial documents that you have to provide. For example, in Travis County, you have to provide a proposed support decision, which is a fancy word for a budget. And that is essentially just, assure the court that you've done your work of proving what your client and their children's minimum reasonable needs are. So we're not going in talking about child support and just kind of pulling numbers out of a hat. In Williamson County, you have to file a certification that you've attempted to mediate, because that is a requirement under the local rules in that county that you can't go to a final trial. And like Jake was saying, if you don't have that on file, or you haven't done your mediation like you're supposed to, you can get bumped and pushed way out. And that causes delay for your client, incurring extra costs, and just the fact that they can't finalize their case like they thought, they had prepped up emotionally to do that. So that's a broad overview of the what pretrials entail and what their purpose is.
Yeah. And I think, probably my experience is every court in Texas has some form of kind of, well, I shouldn't say that. The urban areas, the courts around the urban areas tend to have specific rules about pretrials. So like Stephanie was saying, we're not just rolling in, trying cases by surprise, and the judge doesn't know what we're asking for, the other side doesn't know what we're asking for. That's not how it is done in most counties, particularly the more urban areas, or the counties surrounding the urban areas. Um, and then so let's talk too. Stephanie mentioned it can be awful if you don't do this. You may get reset, or a judge could move you. You could just have the claim denied. Let's talk about logistics too, because it's a lot of court and this is something that people don't realize. A lot of litigation getting the courthouse is a logistical exercise, right? I mean, obviously, a lot of litigation is showing up, having good cross-examination, direct examination, opening statements, being able to present evidence and everything. That's obviously a big part of litigation, but no different than like a military operating. There's just a lot of logistics behind it that can screw it up, right? I mean, just if you think about like a military operation, obviously there's the actual operation of the battle, to make a kind of a stark analogy, is the actual operation of the battle, but there's the logistics of how do we get everybody there? How do we make sure our soldiers are fed? How do we make sure that everybody's where they're supposed to be? Litigation's frankly no different. There's a lot of logistics that goes around the background, and your whole case could fall apart just on a logistical problem. So not the least of which is making sure that your case is properly set, and before the judge, and everything's happened to where it's on the judge's calendar, and he or she is going to hear your case, or the court administrator, if you're in a county with a central docket, the court administrator has what he or she needs to be able to assign you to a judge. So I guess talk to us, Stephanie, about kind of what your role and the associate and the litigation assistant's role is in knowing the local rules and knowing how to get cases set to where you don't have that awful experience where you geared up for final trial or a hearing or something, you roll up at the courthouse and you find out that your lawyer didn't know how to actually set the case and there's no judge for you today. So how do you all kind of handle that? And first of all, how do you learn that? And then how do you handle that kind of in the day-to-day?
Well, fortunately, at Walters Gilbreath, we have a huge brain trust, right? So part of learning it is just making sure you're running things by each other, constantly in communication, and not shirking, the benefit of having really experienced people around you, whether that be Jake or many of our other partners. I mean, we preach preparation. We have this whole setup where it's, okay, so we've got a trial setting. We meet, 2 weeks out, we meet 30 days out, we meet 60 days out to be sure that we are on track to be meeting all of these requirements so that we're not caught unaware, right? So instead of saying a week out, oh no, we're not on the docket, we're looking 90 days out and saying, are we on the docket? Are we adequately set? Are we announced for the correct amount of time? So, I mean, that's the first thing, right? It's just being on top of the deadlines, being forward thinking about what's going on, right? We've got lots of internal forums for each different, county and how those are specific. And we work together to make sure that we're all kind of checking up on each other to ensure that we're meeting all those requirements. But, for example, with settings, in Travis County, it's a central docket, which I'm sure we'll talk about in a little bit more detail in a moment. You kind of can just go on and get it set, right? But you got to make sure that you get the actual confirmation that it has been received and accepted. I mean, the setting could get rejected and you'd be completely unaware. So you have to be following up with all of these things. In other counties, you've got to call and get the setting, and you can't just set it for whatever day you want. You got to get the court's availability. You've got to show that you've worked with opposing counsel or opposing party to get the agreement on that. There's specificity to each county, and it's dependent on whether it's a central docket or not. It's dependent on whether, you're assigned to a specific judge. It's dependent on how big their dockets are. If you're in a more urban versus rural area, all of those things play into effect in the preparation. And then on the other end, you've got to make sure how am I getting my evidence in front of the court? Does this judge require that I exchange my exhibits a certain amount of time before trial? Does this judge require that I provide, or the local rules require that I provide a witness list? And if I don't provide a witness list, I might miss out on a key witness that's going to prove a key part of my case. Is the court going to allow me to have a witness appear remotely because they're in another setting, in another location? Have I done what I need to do to prepare the court to allow the witness to appear remotely, right? There's so many logistical, do I have to have paper exhibits, or does the court allow them to be electronic, right? I mean, and that's why, I'm just rambling off kind of, the big things.
Right. Top of your head stuff that we have to deal with.
Right. And I mean, fortunately for me, one of my favorite things is just kind of checking things off a checklist and, being in control. But I mean, that's why we start way, way, way out, because we know that if you get caught unaware about, I haven't, filed the things I need to get my witnesses and my exhibits and, all of that in, then, there's a point of no return where you're just SOL and you really can't fix that problem anymore. And you're going and trying again unprepared.
Well, and it sets talk about setting a bad tone for a trial. It's even if a judge is going to show some grace on, you haven't filed something directly on time, or you didn't know how she likes exhibits, or you didn't know which exact forms. And maybe she says, well, that's, this is how we do it, but I'm going to give you leave to do it. And that happens because our judges ultimately do want to get the information and see the administration of justice and look out for the best interest of children. So, they may show grace, but that's a bad way to start a trial, though, is with having to beg for grace on something because you didn't know your local rules. And from the client's perspective, how nerve-wracking, right? Like, you start off a hearing or a trial with your lawyer not knowing, how something works in a particular county. We can obviously litigate cases in counties or in front of judges that are new, but there's a advantage to knowing how something works, and what better way to show a client that you don't know the way it works than to flub something, like dealing with the setting or the local rules, or like you were saying, exhibits that are either, some judges want them virtual or electronic, some want them hard copies, some want kind of a mixture between the two, and you need to know those things. So I guess talk to me then, Stephanie, about, because you had mentioned central docket, and those of you who listen to the podcast know from other episodes, there's two central dockets in the state of Texas. It's in Travis County, Texas, and Bexar County, Texas. They deal with central dockets, or they have central dockets. So what does that mean, Stephanie, of a central docket as opposed to a county like Williamson County or Bastrop County, where I'm assigned to a particular court?
Sure. So when you file your case, you'll have a heading that says, you're in the 98th Judicial District of Travis County, Texas. And that's in Travis County, that's more of kind of just an administrative assignment. It doesn't have any bearing on what judge you will be before. So what it means in Travis County to have a central docket is that they take all of the district judges and they put them on what's called a rotation, and they rotate in and out of family law and general civil litigation. So at any time, depending on just when you're being heard, there will be certain judges that are available for family cases and certain judges that are not. If you've had a temporary orders hearing in front of a judge and you happen to have been in front of a district judge, there is no guarantee, and probably it's pretty unlikely that unless there are certain issues in your case that the judges decided to retain your case in front of them, it's very unlikely that you'd go to that same judge for a final trial. So that really, and then the other thing that I would say is that Travis County is very reliant on the use of our associate judges in family law practice in terms of interim orders, things like motions to compel discovery and temporary orders, even things pre that final trial, that final thing that'll get you that, SAPS or order that'll get you that divorce decree. And so with that, often, unless you waive the ability to go in front of a district judge, if you're in front of an associate judge for all those interim things, you're definitely not going to be in front of the associate judge at a final trial. So what that all means for your case and what that means for me and Jake when we're talking about your case and thinking about how to prepare is we have to know that we don't necessarily have the privilege of coming into a hearing and the judge remembers you and remembers the issues that came up at the last hearing and is able to kind of jump right in and pick up where they left off. We've got to be making the presentation a little more thoroughly and clearly every time we're in front of the court, or at least be prepared to do so. So that's obviously distinct from if you go to, for example, Williamson County, you will be told, okay, you're in the 425th District Court, and that means you will be in that court every time you have a hearing. You will be in front of that same judge every time you have a hearing. When you go in, she'll say, okay, I remember this case from the last time, and we talked about this, this, and that, and I ordered this and that for these reasons. So there are pluses and minuses to this, to either way, right?
So let me interrupt you on that because I want to talk about kind of the time of how much I can have for a hearing, because I think it kind of ties into this discussion about the central docket. So what's your experience tying into that? If it's with these four, let's do these four specific counties: Travis, Williamson, Hayes, and Bastrop. What is, let's talk about final trial, and then let's talk about in temporary orders as well if you want. How much time can I get for a hearing in front of a judge, and how is this sort of docket system that you're talking about going to affect that?
Sure. So, kind of as a general framing, the more urban the county, the more you can have in front of a judge because of the way that the system is, because there are more resources, there are more judges, there's an expectation of a larger docket. So for example, in Travis County, the balancing act is that I could set a hearing right now for 2 weeks from now. But I've got to go look at how many settings are on that, because everybody can set the hearing for 2 weeks from now, right? I mean, I'm not the only person who can do that. I don't have to ask permission from the court. I don't have to ask the court's availability. I can just get on the docket. And I can say, I want 2 weeks, right? Now is that realistically going to happen? Probably not, right? Because then you've got to be talking to the court administrator about, okay, well, is there even a judge that's available for 2 weeks? Does my case warrant the 2 weeks? But technically I can announce and say, I want 2 weeks and I need 2 weeks and I have 2 weeks worth of evidence to go through. It's still a balancing act in terms of practicalities of, are you going to get reached? Does the court have the time to do that? How many people are in front of you? And so we're always doing the kind of strategic analysis of making sure we have enough time to present all the evidence we need, but not taking up too much of the court's time that we're getting bumped back and not being able to be reached. In contrast, if you were to reach out to Williamson County or Hayes County, so for Williamson County, it's pretty much a middle ground, which feels right because it feels like it's less urban than Travis County, but not quite as rural as Hayes. For that, you'd say, okay, well, I need a full day. And then they say, well, we only have certain full day weeks. So you can, your options are limited and here are the limited options you have. And they're probably going to be much further out than a day you could get in Travis County. But you have more of a likelihood, more of a surety that you're going to get reached because the court is saying, well, I've made specific time for you on my docket, right? You haven't just entered into this crapshoot and picked a date and hope that you get reached. I'm telling you that there's space for you here. And then in Hayes County, you'll probably get told you have 3 hours, figure out how to get everything in 3 hours. If you want more than a day, like good luck, like maybe you could prove it to me, but you're going to be months and months and months out. You're going to have to fight, not fight, but you're going to have to really convince the judge that you've earned it, that it's worth it. And same with Bastrop County. Bastrop County and Hayes County will operate pretty similarly in that regard. So it's an interesting kind of fun for us, right? Because we geek out about this stuff, but it's fun to kind of think about the balance of, okay, well, you can get a little bit more time in Travis County, but it's a little less sure. And, we have to kind of think about all those contingencies.
Yeah, they all have their ups and downs, right? I mean, the central docket, I think I've preached in other podcasts, you can get a hearing quicker, most times quicker than you can in a different county that doesn't have a central docket. But yeah, like you said, you could roll up in Travis County and say, well, I'm on the docket. And it turns out everybody else sat there hearing that same day and you're just waiting around and they may not have a judge available. That's an awful experience. And there's no way of knowing that until you get down to the courthouse, as opposed to, having corresponded with a specific court's coordinator, in saying, you are set before this judge in this day, and we know that it's going to go. Of course, even then, judges are, at the end of the day, a lot of them are sort of triaging, right? They've got lots of things to deal with, lots of cases. Every single case is important. My experience with our judges is they take every single case very seriously and try their best to give it the time that it deserves while triaging, though, right? It's just like, I just can't spend 2 weeks on one case. Some of them can't spend a day on one case when there's certainly a day's worth of evidence, and they're just dealing with those logistics of how do we do that. So, in Williamson County, for example, you may see a final trial that goes 3 hours one day, and then you're coming back in 2 weeks and going, we're going to do another couple of hours here, and then you're coming back in a month, and we're going to do a few more hours here. I mean, I've had cases that get tried over the span of 6 months, because that's just logistically what the judge has to do to give you the time that the case needs. While, opposed to, Travis County, where you start with the judge, except for in the rarest of circumstances, you're there with that judge until the case is complete, and there's not going to be gaps. Like, you're with her from start and day to day to day until you're done, again, with the rarest of exceptions. And obviously breaks if the judge has a conflict or she has something that she needs to do in the afternoon. You may have a break in the afternoon, but if you start trial on Monday, you're going to be there every single day until your case is complete, as opposed to, and I think a lot of that's because they have the central docket, right? They have the other cases can be backed up by other judges on the docket, as opposed to Williamson County, right? If you're Judge John McMaster in County Court 4, you are it for all cases filed in County Court 4 in Williamson County, Texas, and you got to deal with that, right? So you can't necessarily put your head down and have 4-day trials back to back to back. Sometimes, but in the rarest of circumstances. But yeah, like you were saying, Stephanie, it's nice to know, like, geek out on it, like you said.
Right. Well, and another thing that you had just brought up when we were at the law school speaking, is that, in Travis County, we've got specific criminal courtrooms. When you're in more rural counties, they're seeing family cases and criminal cases. And if you've got a big criminal case in front of you, they have a constitutional right to a speedy trial, right? So that's another thing to think about. Like that can throw a kink in kind of your ability to get before the court. Is that, really, in Travis County, it's a more level playing field. We're all family law cases, right, in front of the people that are on rotation for the family law docket. But in other places, you might be fighting with criminal cases and being reset repeatedly just because those cases are going to take priority with good cause. So that's another thing to think about.
Yeah, and I guess let's end with sort of talking about a major question I get from people. I got this question in a consult just yesterday: virtual versus in person. Right, during the height of the pandemic, everything was virtual. Then each court kind of opened up differently on their schedules. But as we sit here right now in 2024. What is kind of, Stephanie, let's again focus on kind of those four kinds. What is the status of kind of virtual versus in-person hearings and the availability for those?
Sure. And of course, this all is, framed in the favorite attorney caveat of it depends, right? A lot of times crazy things happen. For example, right now we're dealing in Travis County with a pipe having burst in the courthouse. And now we're turning every in-person hearing either into a virtual hearing by agreement or it's getting reset, right? So all of this is, a bit of a moving target, but in general, Travis County has the presumption that your case will be in person unless you agree with opposing counsel or opposing party in writing and submit that to the court the week prior that you will do a virtual hearing. So it's becoming more and more rare. It used to be frankly, the flip of that, as we were transitioning out of the kind of more pandemic heavy, time, it was more that we presumed it was virtual, and then you'd have to request an in-person hearing. And now we've kind of flipped to the opposite side. So that's, again, another reason why we prepare. You've got to send in your announcement as to whether you want to do virtual or in person the Wednesday prior to your hearing. You don't want to be on Wednesday at 11 a.m. saying, oh, I didn't talk to opposing counsel. I want this to be virtual because my client's in Virginia, or whatever. So, that you have to think about those things ahead of time. In Williamson County, it is pretty judge specific. It depends on what judge you're in front of. Some of the judges will have virtual days and in-person days. So you can request specifically for a virtual day or an in-person day. The thing about that is that still you're going to have to be in agreement with opposing counsel on how that works. They're not going to just set you if you've got opposing counsel, objecting to a virtual setting or an in-person setting or whatever. They're probably what'll happen is they'll have you come in and talk in chambers and say, okay, you guys are on the virtual or the in-person setting. But they'll be a little bit more hands-on because it's judge specific, right? This Judge Arnold can say, I'm choosing that you guys are going to do virtual because this client's in a different state. And then there are some judges in Williamson County that really are just going to do in person unless there's a very, very, very strong reason why, in which case you'd have to file a motion. You'd have to request for the court's permission to have a virtual hearing or have a virtual appearance of a witness or a party. Another thing that I didn't mention in Travis County is that even if you're in person, the courts are pretty open to having virtual witnesses. They know that experts, they're busy. They've got, if you've got a therapist, they don't really want to be disrupting their entire practice to have them come sit at the courthouse. So, but again, you've got to be filing your motion or request for that virtual appearance and be aware that you need to ask for that. Court's not going to be happy if you show up and you say, oh, by the way, Judge, can you circulate a Zoom link in the next 5 minutes to have my expert witness, that's my key witness that I need to prove essentially all my claims, testify. It's one, not a good look, and two, it's frustrating to the court because they're juggling 18 balls at once. So, and then in Hayes County, even less likely you're going to get a virtual hearing, right? I mean, I imagine you could go in front of, for example, Judge Hayes, and you could express to him the need for it. I've been in front of him on certain small matters where he said, hey, I don't really want to make you drive all the way down from Austin to do this. But in general, you'd be assuming that you're going in person there. Same with Bastrop County. So, again, it's kind of, you can see the trends of, the more urban places, they have the more resources, they have more staff, they have more ability to kind of, have one judge be taking all virtual hearings that day and one judge be taking all in-person hearings that day, right? And kind of be a little bit more flexible with that. And the smaller counties with just less staff, less support need to be a little bit more rigid, need to be a little bit more predictable.
Yeah. And all this comes down to kind of you sort of sense the theme through this podcast episode and in other episodes is it's just important to have a lawyer who has the experience with this. And even, we get consulted and hired all the time to be local counsel for people, right? Like maybe for whatever reason, somebody has a family friend or they hire a lawyer from a different part of the state that's representing them. Maybe that client's out of, maybe they're from Lubbock and they have their family friend that they want their Lubbock lawyer. But the cases in Travis County, we get hired a lot as local counsel to help people go through these rules and make sure they know the judges, know the rules, know how logistically it works. That happens quite a bit. But from the client's perspective, I would think it's just always important to have somebody that's got that experience, right? And that goes back to the consult. When you're talking to whatever lawyer you're thinking about hiring, all this other stuff we've talked about, you have to talk to them about communication and, what their experience is and how they see your case, and it has to be a good fit. You should always, make sure that you feel comfortable with the lawyer. But part of that conversation should be like, hey, what's your experience in this county, this judge, for a county that you're filed and who the judge is. So it's not a central docket. So you're hired, you're filed in the 425th in Williamson County, Texas, right? But what's your experience with Judge Betsy Lambeth? Who's the judge there right now? That should be part of the conversation in the consult, and having either one hiring a lawyer who has the experience or that lawyer doesn't have the experience, but you think that's the lawyer that you want to hire, then making sure that lawyer has somebody as local counsel kind of help them through this. So, that's something you'll see us kind of preach routinely throughout this podcast series of just there's so much that goes into the administration of a case, and particularly when it comes to litigation, there's so much that goes on behind the scenes that can have frankly, a negative impact on the case if it's not handled appropriately. So to steal Stephanie's phrase, that's why we geek out on it. That's why we like it. That's why we train on it. That's why we have procedures in place, just to make sure that we're checking those boxes and making sure that we have a smooth transition to the courthouse and smooth presentation by the time we get in front of a judge or a jury. So we'll wrap up with that for today. This was the third episode in our local county series. Next episode, our team's going to be discussing the counties in the Houston area, so stay tuned for that. As always, if you like what you've heard today, do us a favor and please leave a review. We appreciate all the feedback, especially when it helps us better the podcast. If you have any follow-up questions to this episode or anything else we've talked about on the podcast, or if you want to talk to one of us directly about your family law situation, you can reach out to us at podcast@waltersgilbreath.com. You can contact us directly through our website. And again, thank you for Stephanie for being here, and thank you all for listening.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreath.com. Thanks for listening. Until next time.